client, which my client in this case being DMH clinicians, hospitals, it's a good springboard, a good segue to the other discussions about what your goals are. Are there other alternatives currently available to achieve those goals? And we look at, what the client's expressed preferences are, because we at DMH, our mission is to honor the choices of our consumers, and it's a person-centered approach. And sort of getting to the 1.14, which at times is a client-centered approach to lawyering. And in our case, we're trying to look at what this consumer wants in their life and whether we can achieve that through guardianship. Is it more appropriate to look to another method, whether healthcare proxy, power of attorney if appropriate, enhanced clinical services if they might be available, other legal instruments. And we take into account public safety, personal safety, clinical diagnosis. There's also, at this initial stage, is an education component. So I think when we go through this form and we discuss the court-connected dispute resolution services with our client and with staff, we teach them a little bit about guardianship in the spirit of the MUPC, limited guardianship, and assessing what the client can and cannot do. So it's a really nice discussion to have, and we're mandated to file it. We do it in every case, and it helps to educate your client at the start of the process so that you're not, at trial and they say to you, why didn't I know about this ahead of time? And I have done dispute resolution in cases not connected to formal dispute resolution, as was discussed on day one. Whoever was here on day one, Chief Justice Ordonez was here, and she described a single issue dispute resolution pilot project, which is down in Norfolk County. I've often wondered whether that would be useful in some of our cases where we can narrow the issues once guardianship's been filed and once there is a dispute, in particular issues of medication. Oftentimes we have even disputes to the dosage range of antipsychotic medications, and whether we could get the parties together and have an afternoon to discuss that and perhaps resolve it outside of court. Because one of the other discussions early on is, as I think Lisa Colquier said earlier, do you really want to go to court to begin with? In our case, do we really want to go to trial on these cases? Because you're balancing the clinical relationship in every case. Everyone wants, as the doctor said, it's a goal-oriented process. We want to achieve the goals of the client and the clinical team, and there's a balance. And do you really want to be up there in every single case in an adversarial contest? And I think the answer is no. I really, as far as I'm concerned, I wish these cases would never go to trial. I think that there is room for compromise in most cases. And while I do have the duty to zealously advocate, I think that where there's so many interests and so much passion and emotion involved, that the best way to deal with it is to reach some sort of an agreement. So that's Rule 1.18, Subpart 5.
Thank you. It sounds like that goes along with Petitioner's Counsel's ethical obligation to discuss with the client how narrow it should be and try to figure out beforehand how much you can get the petitioner and respondent on the same page.
Yes.
Have you been submitting the green forms, the 1.18 forms?
What we do is in every case we'll file along with the
Trying to hold it up, maybe to.
This is called the Uniform Counsel Certification Form, CCF 3-00.
And if the court submits it, it's a green piece of paper.
Correct.
Yeah.
So we do that in every case, and I think as we discussed prior to the conference, there are some cases where it's pretty clear. The issue is informed consent. You go in, you file it, and you've had that basic discussion, but you're now having a prolonged discussion about it, and you zealously advocate your petition for guardianship or in Rogers authority or whatever other authority you're seeking. So
sounds good.
Yeah.
Quick note that I haven't been filing them for ages, but I understand that they are still an obligation to do. So starting tomorrow, I'm filing them. I recommend y'all do too. You should have in your packet a hypothetical It looks kind of like this, but without the blue writing. There's hypotheticals in the top left.
I stole your pen.
Anybody want to read it out loud?
I don't have pens that nice. You can have that.
Anybody have any interest in reading it out loud? To spare people my voice, or I'll do it?
No, go ahead,
Go ahead, Gary.
Getting my
it's
revenge, your revenge. So hypothetical number one.
Have the email.
Let me know if I'm going too fast. Respondent, who is in his late 40s, tells his attorney he wants his mother to be his guardian. She's helpful to him, supportive, advocates when needed, and is working with him to help him advocate more for himself. He reports that he would feel more anxious without her as his guardian, and that he would feel more anxious without her as guardian, less anxious with her as guardian. Even if she doesn't take any action, just knowing that she is his guardian would, he believes, help him feel less anxious and better prepared to tackle his days. When he sees the psychiatrist, he asks his mother to go with him. She's reluctant because she wants his time with his doctor to be for him, and so she regularly ducks out earlier and earlier when he's feeling less anxious and he's okay with her leaving. It's clear that the respondent wants his mother to be his guardian. The family does not have the funds to hire an attorney, so the mother is acting pro se, but she's never had experience with the guardianship process before, and she doesn't know quite how to do it. She ends up going to the courthouse quite a few times, but each time there's something that she's missing. She had a medical certificate the first time, but not a clinician's affidavit. The next time she went with both documents, but she did not have a proposed findings of fact, conclusions of law. When she went back for her third hearing, she had all of the documents, but the medical certificate was now stale. Her missing work multiple times is leading to increasing financial difficulties for her and her son, who lives with her, and she's been threatened with losing her job if she takes much more time off, especially in light of her boss not believing that it is taking her multiple trips to the courthouse to do something that her son wants to have happen. Early in the process, the respondent was appointed counsel. At what point, if any, would it be appropriate for respondent's counsel to help her client's mother with the process? And if so, what help would be appropriate? Do you want to go on down the line?
I'm going to jump to Karen first.
Okay.
Because I will say that the one thing that is the court's interest in your interest as counsel don't line up. The court's interest is to have these things happen in an expeditious purpose. And judges will often ask you to do things, maybe not in this exact fact pattern, but on cases like this, to do things. And you may not think you can ethically do those things. Most judges, they're not necessarily trying to put you in a bad position, but they don't see it exactly the same way, and it's not really, but it's also not their ticket, et cetera, et cetera. So you have to make an independent judgment about what you think your ethical obligations are and not be swayed by what would be expeditious. That's the view from the bench.
Well done.
All right.
I think on the straightforward question of if the judge asks you as respondent's counsel to assist a lay petitioner with the pleadings or the filings, what we've instructed our attorneys is that even as difficult as it is to, say no to a judge who wants you to do something, you need to politely, say, my role is as respondent's counsel. And I know that they may be limited and the services available may not be consistent across the state, but that there are lawyer of the day programs in the different courthouses that I believe are designed to assist with this problem. There's the Volunteers Lawyer Project as well. Sarah, I don't know if your clinic. I would certainly not just shut down and refuse to speak to anybody, obviously, but make sure that the person knows of those other resources that are available, and again, politely tell the judge that.
All right, so I'm going to follow up on that. So in this case, the client, who looks like he's making a relatively reasonable decision of what would be better for him, is instructing his appointed counsel that he wants this, this is what he desires. So if you're being client-centered in decision-making, why cannot CPCS counsel help with this?
Because I have a lot of questions about this hypothetical. First of all, what age is the client? We have a lot of petitions where somebody is turning 18 And the school system, the service providers have said, to the parents, you need to file a petition for guardianship. Someone at 18, and it only talks about anxiousness, but setting aside people with developmental disabilities for a second, just focusing on mental illness, somebody who is 18 may have some emerging mental illness that may make them incapacitated. It may not. They may simply be, as a function of maturity, they've always had their mother help them with decisions. Their mother, it's great that this kid feels less anxious around his mother. I hope that when my son is 18, he says, I make him less anxious instead of more anxious. So that's great. But I think for an initial guardianship proceeding in particular, or any first guardianship proceeding, regardless of the age of the respondent, you need to look at what are the factors that would allow them to prove incapacity. Anxiousness, to me, doesn't equate with capacity or incapacity, and I think the burden is on the petitioner to prove incapacity. Then I think you look at alternatives. It's great that he has a good relationship with his mother. If there is incapacity in the area of, medical decision-making, is a healthcare proxy, a reasonable alternative to guardianship? So I think there's a very specific role for respondents' counsel here, but I think that without knowing more about the genesis for the initial guardianship petition and really satisfying ourselves that they have the ability to meet the burden of proving incapacity and then fully exploring the alternatives, it's not, even though our client is saying, I'm comfortable with this, I want this, and I acknowledge that the UPC, and Bob and I have talked about this before as well, that the MUPC sort of allows an individual to petition upon themselves, and that there's a lot of direction, obviously, for us to take, our client's direction. But whether or not that's, an informed decision where we've advised the client that there will be an undisputed finding of incapacity, and therefore we better look to alternatives, I'm not there at all yet.
But I think it
thanks.
gets to the duty of loyalty. When you're an attorney,
Yeah.
you have to look at, in this situation, particularly with families, it's very difficult when the interests are sometimes aligned and at times they're not. And you have to look at who's actually making the decision. In my experience, we've had family members get involved where when you get the family in a room, it's clear that there's pressure being put on the incapacitated person with regard to certain issues. So I think there is that a little bit of investigation that has to be undertaken here. And if their interests are aligned, then that creates an ethical dilemma in that maybe it is a time when there could be a limited disclosure or a limited cooperation with them on this issue, whether it's to refer them to the Volunteer Lawyers Project, Suffolk Law Clinic, whoever. We've had cases where that happens. What happens after that is they look into whether they're eligible for other services. They may become eligible for DMH services. The petition gets filed. Eventually, because they're an eligible consumer of our services, we intervene, and the case takes on a more balanced and organized approach before the judge. So in the interest of judicial economy, the case goes much smoother. Like Judge Dunn said, sometimes you're being asked to do things that are beyond the scope, but the reason is so that the case may proceed in an orderly fashion, and it would help you also, rather than dealing with a pro se client in the long run.
All right, so I can't let you, Karen, I can't let you get off the hook so easy, because I'll put it this way.
Of course not.
We often, you're right, 90% of this hypothetical, let's just say it's a DDS case where the young adult is turning 19, 18, all the information's there, the person is clearly incompetent, all right? And the mother or father or caretaker, future guardian, needs help with the mechanics of it. There's no doubt that there's programs available. They're not statewide. I think one thing everyone in the room will agree with, there's not enough services for mentally ill developmentally disabled people and their families, no matter where you are in the state. Why cannot the CPCS attorney, when it's clear, why can they not help on that situation?
Well, first of all, I don't think it's clear. I think the duty of loyalty, I think if you have a medical certificate that may be a stale medical certificate, yes, with in that case, it would be a clinical team report. But again, I don't think that just the mere pleadings without, in the interest of kind of expediency and making sure that these cases are processed quickly is our role. I think there are DDS cases where, it may look from the clinical team report that the person lacks capacity. And again, I assume we're talking about the initial guardianship. And the other thing I would just say about the initial guardianship is that, this has been termed a civil death. This is a serious deprivation of the person's liberty. And I think hopefully everybody in this room would acknowledge that it's much more difficult to limit or terminate an existing guardianship than it is at the front end to really zealously advocate for your client, make sure that, all the T's are crossed and I's are dotted, you've gotten an IME, and explored the less restrictive alternatives. I don't think we can tell as an attorney simply by looking at a medical certificate or a clinical team report that the person lacks capacity in all areas.
100% agreed, but the counsel's already been out, they visited with the client, they did all their due diligence, and at the end of it, they have come up with no justification to oppose the petition. Why can they not help fill that form out? Is it just because, and I know
think
for
'cause the role is
expedience
different.
purpose, yeah, so it's just that the roll crosses and that's the bright line.
That's my view, but if other people want to
Well,
jump in,
I'm trying to get
that's
that, because I think, to be honest with you, that this is something that assigned counsel face constantly. Am I wrong?
Yeah.
That you put in a position by judges on these cases that are not close calls, and everything is there, and you've done everything, and then it's like, well, yeah, I'm not opposing it, or however it's put, and then it's like, well, yeah, but we need these paper done and no one else can do them, can you help out? So,
I have just a point on this, because I think this discussion is really interesting. We started the conversation looking over the rules of ethics in regards to the specific scope of representation between you and your client. And what I'm hearing in this conversation is, let's not dispute the facts, regardless of who the petitioner is, regardless of who the respondent is. We've gotten to a point where the judge believes that the judgment of the lawyer involved is that it's sufficient to move to a final decree. There's no opposition. But that CPCS standards are providing some different expectations on what they will or will not do in the scope of that representation, which I think addresses another ethical dilemma, which is when you are CPCS counsel, there is this pull between, who is your client, and what considerations do you have in terms of what the standards say, and is that different than what your own individual judgment is? Just getting back to Bob, your point earlier, which was, in these cases, the rule and yourself rely so heavily on your own judgment in representing your client.
Yeah, I think this hypothetical raises for me, I don't read this hypothetical as creating a situation where the lawyer is convinced that there's no need for a guardianship. I read this hypothetical as not quite the situation that Judge Dunn was addressing, but quite different, which is that you have a client who wants a guardianship who probably doesn't need one. And for me, a fundamental question here is not do you help, although I think it's an interesting question about do you help the mother with this. My question is, do you go to court and stand up and say to a judge, there's sufficient facts here, Judge, in my proposed findings, which you're going to be asked to present, that this person needs a guardian when he doesn't. It's kind of like, for me, the situation that criminal lawyers get caught in, defense lawyers get caught in a lot, which is the client says, I didn't do it, but I've been sitting in this damn jail for 3 months, because I can't make the $100 bail. Just plead me guilty, get me the time served, and get me the hell out of here. And so the lawyer stands up and says, yeah, we plead guilty and we agree to time served, when the guy didn't do it. And I wonder, in the guardianship context, how ethical it is if you can't present proposed findings to a judge, how you stand up and say, yeah, guardianship's warranted here because my client wants it. Because it is a substantial deprivation of civil rights. I mean, it could mean that the person can't vote. It doesn't necessarily mean this. It could mean that they can't marry. It could mean they don't make decisions about health care or where they live. I think it's a real dilemma. I'm not sure how you come out. I'm more concerned about that, frankly, than whether you help the mother. I think if your client wants you to help the mother, I think the CPCS standards here are a little too strict on this one. But I do understand the standards, and I certainly understand the reason for them. And I think it is, I hate to use this word, but it's a slippery slope if the judges suddenly think that the defense lawyers are representing everybody in the courtroom to expedite what's going on. So I understand why you got to build some barriers to that.
Before you take the next question, a quick clarification, then I think Laura is after this question for next. So in this hypothetical, I was as cautious as possible at disclosing this hypothetical person's history, but there's also a thought disorder. And the big thing is that clinically it's helpful for respondent to have mom as guardian. And let's make it even more unfair that the IME says, you know what, his anxiety is really overwhelming for him. He finds mom to be supportive, and that he has a sense of being bound in a good way, of being supportive. And mom is trying as best as she can to be as least intrusive. It's really more the name of guardian. So it's included, the person can vote, basically all the stuff he can do, but to have a guardian, to have that name, to have that word, the respondent feels like he can go out in the world.
Yeah,
Let's address it in a bit, but I was promising people could ask questions.
Gary, I don't think it's a question so much as I think it's beyond the rule and the practice standards that CPCS has. It's also a malpractice issue for the respondent's attorney to assist the respondent's parent in this situation. And
Even if their client's asking for that.
Can their client execute a waiver authorizing them to do that? So there are a couple of other concerns I think a respondent's attorney may have. And I think it's incumbent on the respondent's attorney to speak with that parent and say, I really can't help you, but here are these resources. And there are even more resources than have been mentioned already. And I think it's the best way that a respondent's attorney can help the court to ensure that the parent's rights are assisted or protected, and to get the case moving along, to get that parent to somebody, whether it's Lawyer for the Day, Volunteer Lawyers Project, any program in any county to assist them through a bar association in getting the matter moved along. But also, I think Carlos brought up a great point, which is most of the courts have conciliation programs, and that's another methodology for moving these cases along and resolving them. And I think, it's something that attorneys on both sides should be considering. I don't think court-based conciliation programs are really just for family law. They shouldn't be. Guardianship is another aspect sometimes of family law.
I think you're right. I think there's a guardianship clinic in most counties, but they're only on one day. So then an issue is if this is a judge who hears things on Tuesdays and the clinic's on Thursdays, it's not going to help mom out. I guess to complicate things, then Laura had the next question. To complicate things, would respondent's attorney be within would it be appropriate to refrain from objecting? So, do they have to, in this situation, if it's not helping with the pleadings, are they allowed under the standards to refrain from objecting? And then
We have someone in the back, and then we'll bounce up here, or do you want to?
yeah, she was waiting for a bit. I was telling her she can go, and then
So my only comments was, having been in this situation many, many times, is, I make the objection, and the mom will make her argument, and then leave it to the judge. And the judge will override my objection and not care that the med cert is stale, or the affidavit wasn't included. I mean, that's happened to me many times. I make the objection as I should, and then leave it to the judge to make his or her decision about, you know, is the judge gonna give the mom more time to, you know, get the affidavit or whatever? And in Judge Dunn's enhanced hypothetical, where the son is has developmental disability, I have notified DDS counsel and said, you know, this person needs to be looked at. And it turned out that, yes, the son was a DDS client, and DDS probably should have pursued the petition anyway. And so I didn't have to do anything that I shouldn't have done, but yet the situation was resolved by directing the mom and the court to alternatives to having me do the petitioner's job.
I think the question is, well, on enhancement, and go back to the hypothetical, and even if you, are you obligated, under the circumstances here, ethically, just on this first hypothetical, are you obligated to object to this petition when your client is directing you that that's what they want? And that's really the crux of this problem. And I think there's difference of opinion there, because, and so put away the helping part, when your client seems to have made a considered decision, and you can get into the facts, and obviously there's more facts, but you've gone out, you've looked into these things, and your client's stated position, and there's no issue that you think your client's being pressured and this isn't his true opinion, are you obligated to object? Or, and we all agree it's a substantial deprivation of rights, but that they're agreeing to that, are you obligated to object? And that's the big question. I think reasonable people have a difference of opinion on.
I was just going to say that actually this person sounds like a good candidate for the supported decision-making, where they would have their little notarized thing, and the mom could use that as she needed to obtain information and stuff that she needed in order to help him make the decision, because that's one of the things that comes up a lot.
Quick comment, and then finish your question. I completely agree with that, but in this particular case, and the gentleman's particular symptomatology, he finds it comforting to have mom be. So healthcare proxy affirmation, that doesn't have the same feel for him.
For him.
Guardian's the thing.
Yep, yeah, I mean, I don't know from the position of a CPCS attorney, it seems to kind of go against what I know of CPCS's kind of mandate and charter, that the question of asking the CPCS attorney to assist the mom with the petition, that was what I was thinking about. But the limited assistance representation, a lot of people are, a lot of attorneys now are certified to do that. I don't know if any of the CPCS counsel or attorneys there are, but you don't actually represent the person. You're just assisting, really, to put together the paperwork sometimes for the person. Very limited and narrow way of addressing it. So I'm just mentioning that as something that could maybe factor in somehow.
Thank you. Thank you. Sarah?
I represent petitioners, not in court, but in-house for hospitals. And I actually, a couple things. One is that I feel like sometimes, especially when you have practitioners who are not familiar with the guardianship process, when the attorney comes in from CPCS representing the patient, there's sometimes a misunderstanding about what that means and kind of what their role is. And I actually think that this discussion really brings forward some important issues around that. And I agree, actually, with the position that the CPCS attorneys here are taking, which is that I think it's very helpful for that to be very clear to everybody what the role is of the attorney for the patient or for the respondent, and what the role is for other people in the process. So I actually think those lines are important. I think when they get blurred, it starts to be very confusing, both for the respondent, for the potential guardian, for certainly for the practitioners involved. So I actually think that there is some usefulness to keeping that, and I think from an ethics perspective, I mean, I'm constantly having to explain to my clients when they're like, why is this CPCS attorney so obnoxious? And I'm not saying that rude, I'm saying like, why are they taking this position? Clearly this patient needs help, and why are they standing in the way? I'm like, it's their ethical obligation to do that, and I think this discussion has really brought that forward. So it's not so much of a question, but I did want to say that I think it's helpful even from the respondent end, from the petitioner end.
Thank you. So I just wanted to, first of all, thank you for that perspective and acknowledge that we at CPCS, the Mental Health Division, does not have a separate training department. We're the only division that doesn't, and we are providing some very long overdue training specifically for existing panel members on representation. And the first thing on the agenda is role of counsel. You know, in guardianship cases, it's statewide, it's mandated, it's full day, it's starting in November and going through May or June. So I just wanted to thank you for your comment and also, you know, acknowledge that we understand that we haven't done probably the level of training for our attorneys that really would have helped them, I think, in some of these situations. But also just a final comment on the role, and if your client wants this, I appreciate that Bob brought up the analogy to the criminal context, because I do think it comes up in civil commitment cases, it comes up in guardianship cases where there's sort of this view like, well, don't we all know that this person needs help? Why does this have to be litigated? Why does this have to be adversarial? And you know, in no other area really that maybe, I don't know, CAFL, but you know, children and family law, in no other area where there's a substantial deprivation of a client's liberty do we question why it has to be adversarial or why the defense attorney has the role that they have and why can't they just get together with the prosecutor. And if there is a plea bargain, it has to be, you know, the judge has to do a colloquy, the client has to be competent, you know, so nobody sort of questions these roles and the blurring of these lines in other areas. And I know it's not the same, I'm not implying that it's the same, but just think about something that Michael Perlin calls saneism, which is, you know, like other types of racism, you know, and discrimination. Are we not consciously, but unconsciously adopting a standard of advocacy or a lesser standard for people with mental disabilities? So I'll just put that out there.
I see it the opposite in a way. I think that for people to say, why are you representing, don't you need help? I think clinically, it's absolutely crucial that the respondent feels like they have agency. They have a sense of efficacy. There's somebody standing up for them who's going to support them and listen to them. Crucial. Yep. I don't care if it's a slam dunk. If that's what that person wants, you have an obligation, legally, standards, ethically, you must do that. My concern is if the person wants the guardianship, and so clinically, how does it feel to them? And I'm petitioner's counsel just about always, and a clinician. How does it feel to them to have that lack of agency? That they're saying, attorney, let's work together. I know you're on my side. This is what I want. It's fairly reasoned. This is what's meaningful to me, and I'll bring Bob into this, and as being as respectful as possible to the respondent. If they object, you must object. No choice in the matter. But if they're saying they want it, and it seems, you know, they're not under pressure, it seems wise, what effect on them that they no longer have a voice? And counsel might believe I'm their voice, but the individual, him or herself, might feel very reasonably that they've had their voice taken away. So I'm not sure how we reconcile the two.
Yeah, I think ensuring a voice is absolutely critical. Gary's absolutely right, and there's literature in the social science literature that shows that that people who have received a good defense in civil commitment cases and lost are much more likely to be cooperative to treatment than people who got a lousy defense and lost. And that the sense of being listened to and heard is really important. I just finished a very long guardianship case, and I think and we had two of us defending it, and I think our relationship with our client, who has in 30 years never been listened to and never had her opinions validated, that the relationship that she had with her lawyers was an extraordinary relationship for her, and I think it's really, really important. I think in this hypothetical, if the guardianship is warranted, because as Gary describes it, this is such an important thing to this client. I think to undersell this client and not to follow the client's wishes is really undermining the client. I would have trouble doing it if I thought that the guardianship wasn't warranted, but I think I would stand up for my client's wishes. I think it's important. I would spend a lot of time counseling him. I'd talk about limited guardianship. If he needs his mother in with a psychiatrist, can we limit the guardianship just to that issue? What are the things that cause the most anxiety for him and make him the most troubled? Can we limit the guardianship? Can we have the mother filing meaningful annual reports which tell the judge, I no longer need this authority, those kinds of things? I would really try to tailor it. But I'm very uncomfortable standing up in court and taking a position that's contrary to what my client wants. I think, unfortunately, the SJC and the appeals court have been awful on this issue. That lawyers who have stood up and taken positions contrary to what their clients want have been validated by decisions by our appeals courts. And I think that the appeals, in the most recent one, when the civil commitment lawyer, I think it was a civil commitment lawyer, got up and cross-examined his own witness, his own IME, in order to help the